Good morning, good afternoon, good evening, good day. My name is Jason Weiss. I am your host of the Ask Jason Weiss show. I am a practicing attorney, a legal consultant, and one of the things that I am trying to get more and more into is mediation. So first thing I'm going to talk to you about today is that nothing discussed today is legal advice. Should you need legal advice, seek legal advice, or need anything like that, consult an attorney directly. Nothing on this is privileged. Nothing on this is communication between an attorney and a client, and no relationship has been established between any of the listeners, myself, and our wonderful guest today, Mark. And I mentioned the word mediation. Lots of people claim they know what it is, but in reality, many of us do not know what mediation is. So today, I have Mark Greenberg with me. He is our guest, and Mark is a full-time mediator with Breakthrough Mediation. Mark and I have run in similar circles for many, many, many years. I think we finally met in person recently, but we've probably worked together on files. He's a gentleman, a scholar, and we share mutual friends. So that says a lot about both of us. So Mark, tell us a little bit about Breakthrough Mediation, and then I will ask you a couple of questions about what mediation is.
Sure. Thanks, Jason. Good to see you again. Mediation is simply an assisted negotiation with a neutral person helping. I usually describe it as I'm trying to kind of grease the skids a little bit so that a case can settle a dispute between 2, 3, 4 different people. And to do that, we ask a lot of hard questions, and we ask you to consider what your alternatives are and what the legal basis of those alternatives are. Because a lot of times people come into mediation, they want things and they think certain things are morally right, and they could be correct. But what's morally right and what the legal system is permissible may or may not be the same thing. So some of what we're doing is trying to pull that emotion out of the decision-making process so you can focus on what is realistic and achievable, and then seeing if there's a middle ground that we can get the parties to resolve the case. I can tell you that the return on investment at mediation when you settle your case is about 13,000 to 1. So for every dollar you spend to mediate settle it, you're going to get about 13,000 back in terms of what it would cost you to litigate that case all the way through trial.
Now, Mark, I'm only a mediator, certified by the state of Florida for a little over a year now, and it's not the primary area of my practice, but I'll get phone calls all the time from, what an individual, what you and I as lawyers, we'd call pro se people. And they'll call up and they'll be like, oh, I see you're a mediator. Can you handle divorces? And can you be my mediator in the middle of a divorce? And my response is, I don't do family law. I know nothing about divorce. Have your attorney call a family law mediator. I'm sure because you've been doing this longer than I haven't only. Do you encounter that type of phone call ever?
All the time.
Marketing
people, because our primary clients are attorneys and law firms, and that's who we try to seek business from. We don't do business very often with people who don't have attorneys, as you say, pro se, for the reason being that mediators can't give legal advice. We're not allowed to tell you what we think you should do. We're really not allowed to tell you what the law is beyond very kind of broad brush issues. And we can't get into that. So what happens when people don't have an attorney, they usually want legal advice, even if they don't realize it. Deep inside, they're trying to have somebody tell them what they can or can't or should do. And we can't get into that because we're that neutral middle person. We're like, I don't want to say we're an umpire or a referee because we don't make decisions, but it's sort of that, the referee or the umpire can't help out either team. And same thing as a mediator.
It's funny you mentioned that because I had a very, very sophisticated client from up north, the New York, New Jersey area. And I put in, we got an order from the court saying you must go to mediation. and he fought me tooth and nail. I mean, like, you would have thought I said you had to give up your favorite child or your firstborn child if it's not, your favorite. And he said to me, Jason, I don't want some retired judge telling me what I can do and not do and interpret my case. I'm like, whoa, you just blew my mind. And I'm, his name isn't Steve, so I'm going to use Steve.
Right.
Steve, do you know what mediation is? And he goes, yeah, you go in front of, that retired judge and you tell your whole story and the retired judge tells you what's going on. I'm like, no, that's not what mediation
How they do it in New York a lot, because that's not unusual in New York from what I've been told.
Well,
so it's the same kind of idea, but it's a different process and effect.
I think he was mixing up arbitration and mediation. And I think a lot of people don't understand the difference between the two. And so he was saying to me, I don't want it done. I don't mind going in and negotiating and speaking with someone and all of that. I'm like, that's mediation. So for the listeners that are either in law school, new to the law, have no legal experience, I just threw out arbitration and mediation. You want to take a stab at just a quick difference between the two and focus more on mediation? Because are you an arbitrator?
Yeah, I'm we're not allowed to say certified, qualified arbitrator.
Gotcha.
Which it's less training than to become a mediator.
Explain to our listeners and to everybody just basically the quick
arbitration is like an alternative to having a trial. It's one person or a panel of three people deciding the case for you. So they take over the role of the judge and jury, and effectively it's like doing a bench trial. But you can have rules that are very minimized, designed to speed it along and become a quicker process. So arbitration results in a decision. Mediation is a process where we try to help you settle the case on your own terms. And there's no requirement. At the end of an arbitration, you'll get a verdict or an award. At the end of mediation, you might settle the case, you might not. It's your choice, but nobody can force you to do anything. So that's the difference.
So the mediation is more like a group effort where you're, the mediators, and you'll see it, when I've been in mediations in the past, one of the mediators I used, he would always say, I got brand new sneakers for this one. And the clients would always turn to me. They're like, what does that mean? I'm like, because he's going to be running back and forth and back and forth and back and forth and back and forth, which means he's working for you today. He's going to, he's going to the gym. And it's funny. He'll show up, this guy, in a sweatband or new sneakers to break the ice, to make it, kind of relaxing.
Everyone's got their own personality approach, and that's kind of a neat way to do it. And that's back when, right now, 98% of mediations are over Zoom. Once in a while, we'll still do one where we're in person, like you were just describing, where we have people physically present in our offices, and then we'll go back and forth between the different sides, walking or putting miles on sneakers, the way you were describing, to do it. For those that aren't familiar, the way mediation generally works is you start off and have an opening session. Most civil cases, you'll do them in one room with everybody there. Most family law and divorce cases, you don't do that, because you're just going to have people upset and they're not listening. They're just yelling or not happy with each other. In some civil cases where there's some personal issues or battles going on, we'll do the same thing and kind of keep the parties separate. But at the opening statement, the mediator gives a quick opening, which is the thing we have to tell everyone is everything we do is confidential. You can't use it in court. The exceptions are pretty few, and in most cases they don't become. The exceptions to confidentiality and mediation are, if you say you're going to go commit a crime, I'm going to go call the police. I have to. That's not an exception to mediate, to the privilege. But if you discuss, hey, we're willing to settle the case on these terms, or we agree maybe this isn't our best legal point, that does not get repeated in court. And the idea is you can put your cards on the table and be a little more open so that you can try to see if there's a way to settle it. So after I do my little opening, each side will then present kind of an opening statement where they outline the strengths of their cases and why they think they're going to prevail on these issues, maybe not on certain other issues. And then the other side does the same thing, after which we then split up into those separate rooms. So if we're physically there, you'll go to physically different offices and I'll go back and forth. Or if you're on Zoom, I'll move you into, virtual rooms, but you'll still be with your attorney. So you'll be able to see and hear each other in that room, and same in the other 2, 3, 4 rooms. And I'll go back and forth, and you can't hear what's happening in the other rooms, whether it's in person or over Zoom. You have privacy in the setting that you're in with your own attorney. One thing that does come up, you're not allowed to have other people at mediation who aren't part of the case. So you can't have your friends, your kids, other people hearing, because what happens there is confidential. And if you want someone else there who's not part of the suit, when I say part, not named as a person involved in the suit, like a party, you have to get permission from everybody else that they can be there, which happens. So sometimes people want their accountants there. Sometimes people might want, a trusted friend. If you have a person who has a hard time making decisions because they're not always so sure of themselves, it can help to have somebody else there, but you have to get permission.
And I know when I was getting certified to become a mediator, the mediators would have to ask everybody involved if I was allowed to participate as a silent spectator, literally on Zoom with my camera on so they could see I'm a real person and by myself, but with my microphone off. So it is treated very, very confidentially. And I apologize for interrupting your groove.
No, it's totally fine.
I just had a question. I know I mentioned family. Do you mediate all types of cases, or are
we do? We've got several people at Breakthrough Mediation in different areas of law. So, we've got someone who does a lot of divorce mediations. I'll do a few divorce mediations, but candidly, it's not the majority of what I do. There's people who specialize in condominium laws, construction, all sorts of stuff over periods of time. I kind of want to get back to the point you made earlier about, the retired judge.
Yeah.
Because there are a lot of former judges who are mediators, and there's also a lot of people who never were judges who are mediators. So it's not automatic that you will want to pick a former judge as your mediator. You might. It just depends on the case and your personalities involved. One of the challenges that some judges face when they become mediators is this: mediators can't tell you what to do. I can nudge you. I can ask how that's worked out for you before. I can ask, I can ask your attorney, what are the chances of that working in court? Which is usually my clue to saying, okay, you want that, but you have about a 10% chance of getting it. So, but I can't say that, but I can go, Jason, what are the chances you think you win on that particular issue in court? And that's your job, to say, well, you advise your client, hey, we've got a good chance or we don't. But I can't tell you what to do. And judges who have been on the bench for a while and become mediators have to be able to transition from telling people what to do to nudging them. Because as a judge, you just write an order. You will do this by this date, or you'll have to tell me why I shouldn't hold you in contempt. Mediator, I have zero power. People love to ask, do you have a rule about certain things? I'm like, no, because I don't have rules that I can't enforce. So I'm not going to have a rule that requires you to do something.
And I'm gonna chime in and bolster that statement, because there were a lot of retired judges that I've used who I loved them on the bench, and as a mediator, not so much. And there were retired judges who on the bench wasn't a big fan, and as a mediator, it was great.
And there's not a high correlation because it's a different skill set.
Yeah. So one of the former judges who turned mediator that I personally just happened to like as an individual was Judge Eade. I don't know if you were ever in front of him.
I knew the name, but he was down in Broward. I didn't appear.
He was a Broward County judge, and he did a lot of that on the bench. Well, Mr. Weiss, if I were to find your way, what do you think would happen? Da 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 da. And Mr. Weiss, if I don't go with you, what would your client do? He was very theatrical, very this. His motion calendar hearings were very long, but he was. I liked him as everything, as a judge, as a mediator, but few and far between for others. And no offense to any judge that's listening that I've used. Yeah. Sorry, Your Honor. But no, I think it's a different mindset. And I think you nailed it on the head, where it's you, Mark, are not going to say, party A, you must do this, party B, you must be this. It's done. And you have to be very tactful. And I think sometimes it's hard. And I know as attorneys, we understand that. But a lot of times the pro sayers or the people without the attorneys, they don't understand it. And I want to touch on that. And I want to confirm with you, mediation is not an alternative to getting your lawyer to represent you in court. Mediation is a tool in your lawyer's briefcase or utility belt to potentially get a case settled.
It's a great way to put it. I may steal that from you.
By all means, it is.
Yeah, that's really it. It's not, mediation's a tool, and it's an effective tool, but it needs to be done at the right time. If you want to mediate too soon, you run into a problem that you don't have enough information about the other side, and they don't have enough information about you. So to use your divorce example, just because it's an easy one to go through, you have to have certain mandatory financial disclosures. That's part of every divorce. It's automatic, has to be done. Well, until you've gotten that from each other and had a chance to verify that no one's missing bank accounts or not putting the right amounts in, it's going to be too soon because there's no trust that you're working on the right numbers. So there's certain things that would need to get done to have that type of decision made. Otherwise, the tool is perfect. You can do mediation at any time. Now, it is a requirement before going to trial in Florida in almost every non-criminal case. So every civil case, every family law case, and I think probably any case that really isn't criminal or juvenile, the judges will order you to go to mediation before trial. I can't think of a single county that I have not seen that in. And the reason is this: it works. You have dockets because they don't have time to try every case. So they need a way to help thin that out if the parties can.
And if you and your lawyer are so adamant that you don't want mediation, you have to actually file a motion with the court, go in front of the judge and explain to him or her why you don't think mediation will work. And I found it to be very rare that they'll allow it. Your Honor, we did mediation prior to the lawsuit being filed. Your Honor, if these people are in the same room, you will need to enforce criminal charges because they will kill each other. Something along those lines. But now that we're in the Zoom method, it's not a financial thing. It's not a time thing. It's not in the room. It's not traveling type thing. So there's a ton that you used to be able to use an excuse to quote unquote get out of mediation that the courts are saying no.
Then they rarely will let you out. You better be in agreement and even then have a good reason. 90% of those motions, I would say the judges go, you know what? Even if it's unlikely, let's go give it a shot. Let's see what happens. And then you go. Yeah.
And I think it's a phenomenal tool. And it's a great thing. And I'm glad that Florida, insists that we do that. So what we're going to do, Mark, is we're going to take a real brief break here while we run some commercials from some of our sponsors. And when we get back, I want to get back onto the timing question that we kind of started with. And I'm going to throw a tough question at you having to do with timing. So,
all right, no problem.
Mark Greenberg here, www.btmediation.com, 561-712-4717. And what, Mark would, be interested in speaking with attorneys that are getting ready to go to mediation or have, a client that wants to go to mediation. But again, really not the pro se or somebody, hey, I want to mediate a case or something like that, because that's not really what we do. You really need, your lawyer to make that contact. If you like Mark just as a person and want to retain him, that's a different story. But, for mediation purposes.
I don't do anything but mediation, so I don't.
Understood. I got you. Hey, it's all good. It's all good. CC, we're ready for our commercial, and Mark and I will be back, and we'll talk about timing of mediation and showing your cards.
Thanks, Andy.
And we are back. My name is Jason Weiss. This is the Ask Jason Weiss show. Although I am an attorney, nothing herein is privilege. This is not legal advice. This is not privileged information. I haven't been retained. You haven't retained anybody. And if you need a lawyer, happy to chat, but you have not retained me at this point in time. Nothing discussed today constitutes legal advice. Should you seek legal advice, please go contact an attorney and not a mediator directly, which gets us back into where we are today. I have with me Mark Greenberg from Breakthrough Mediation, and he is here with me. And one of the things that we've been talking about is mediation as a great tool in the utility belt of an attorney. And we were talking about the right time. And I know from a practitioner's standpoint, often I will mention to my clients, hey, we should maybe go to mediation. The court's going to order it later on in the case anyway, before you start, going through more and more discovery and taking depositions and doing all of this. And a client will say to me, and that's happened recently, well, I like the idea of mediation, but I don't want to be the one to bring it up because that shows weakness. Mark, thoughts on—
Good question. That's a really good question. I totally understand where the psychology of that comes from. And there's a rational basis for it in many situations. In legal cases, generally not, because everybody in their deep down wants them done, and they don't want to keep paying their attorney for it. So, we track how much money we save in mediation. That's how I know what the return on investment is. And it was, I think last year, we were over 25 million in legal fees saved because of cases that settled. So bringing up mediation doesn't usually hurt, because all you're saying is, hey, we're pretty far apart. Let's see if we can settle this before we spend more money on this case. And the result is also this. This isn't buying a car where, whoever blinks first may end up the worst deal. The court is going to decide the case for you if you don't settle it. So there's a built-in incentive to do it your way. And yeah, so I guess to answer your timing question, I have never seen that hurt anybody say, let's go to mediation. Now, if you say, let's go to mediation before we've given any information out, yeah, someone's going to think there's a problem there because, well, gee, they don't want to tell us about this because it's going to hurt them. So that's probably not going to work too well for you to do a mediation at that point. If the NFL, like in some of their legal disputes, doesn't want discovery, if they push mediation early, it's going to be seen as they don't want to do the discovery. So if we go to mediation, we're going to hold firm and really make them give 80-90% of what we want, because they don't even want us to see what's there. And there's probably a reason for that. But otherwise, no, I don't see any reason. There's never been a downside that I'm aware of, as a practicing attorney, even, to asking for mediation.
Right. And I've had that conversation with the attorneys on the other side. I'll be like, look, we're going to have to go to mediation. We're going to have to do it anyway. Might as well do it now. I understand it's going to hurt your pocket at the end of the day, but we're looking, to get this done. And you could tell your client that I suggested it, and I'm going to tell your client that you suggested it, and then we do that. But I don't think it's like you said. It's not a showing of weakness. Someone has to start somewhere. And also, I've seen it in the mediations all the time where they don't want to open up with a starting number. I'm like, why? Why not? You sued. You're suing for something. What are you suing for? Open it up. $1 million? Fine. $1,000? Fine. Whatever it is.
There's some strategy. And that's called an anchor. And everybody knows wherever you start, you're going to end up having to move. So if you're going to start off, at some point, someone's got to get the ball rolling. I always encourage people to make, your highest plausible number, and on the other side, the lowest plausible. And when I say plausible, you need to be able to answer the question is, how did you calculate that?
Correct.
How did you come up with that? Because if it's a number that you're pulling off on thin air, it's not going to help.
I flipped a coin.
It just needs to be one that has some basis in reality and logic to it. And that's part of the attorney's job. And it's one of the reasons that having an attorney there will help 99% of the people.
Right. So we were talking a little bit about that. Now we're using Zoom as opposed to, in person and all of that. Where do you think the future with regard to mediation is? Are we going to stay on the Zoom platform, or do you think that we're going to get back into, the confines of an office, or, not real mediations usually aren't done in a courtroom, but do you think we're going to be back in confined quarters, or do you think we're going to keep?
I doubt it. I mean, everybody likes doing it online so much that I have a hard time seeing that go away. And the success rate of mediations over Zoom or in person is identical. And every mediator I've talked to will say the same thing. I mean, we tracked it at the beginning of COVID, and we were running around 82, 83% beforehand and 82, 83% afterwards on Zoom. And it stayed the same. I mean, we don't see any difference to it. There is a generational divide for sure. If you go to any of the bench bar conferences, or you see the judges, the older people are, the more they want in person because it's what they're used to. And the younger they are, the less they want it. And the people in, my range of, I'm 54, so the 45 to 60 range, is kind of split depending on what you're comfortable with. I don't see it disappearing. There's a huge economic advantage to it because you don't have to travel. So you don't need to drive. So if you're out of state, you don't need to fly down for this and take time out.
I remember back in the day where if you had an adjuster or a client out of state, you had a motion from the court in order for them to appear. And I guess that's kind of like, do you feel
what would happen on those ones? That's a good point. On the cases where there's insurance involved or large companies where there's higher ups making the decision, everyone's required to come to mediation with authority to settle the case. The problem is this. They have authority. If they sign, if somebody's demanding $1 million and they say, I'm going to settle it for 20 million, that company's got to pay 20 million. They have authority to bind them, but they'll get fired. So the reality is this. When we were doing it in person, they would send a local warm body from a company nearby who would have authority and who literally knew less about the case than everybody else in the mediation. Then when you or I left their room, because we'd separated by that point, the attorney would get on the phone to the real decision maker at home office. And I never got to work with that person. Now with Zoom, I get to see and hear that person. I've developed relationships with them and friends, not close friendships, but we know each other's personalities. I know how they like things. They know how I like things, and they trust because they know if they say something to me, I'm not going to go blabbing it to somebody else. And if I tell them something, they can trust that there's a reasoning behind it. And it's made a huge difference. So we lose a little bit of that in-person shaking hands, but we gain access to people we didn't have before. And it makes it much easier on the parties. It used to be, you know what? Hey, aftercare is done at 4:00. I need to leave to pick my kids up. That's the end of the day. Now, if they're at home, go pick your kids up. We'll see you in 15 minutes. The other side will never even know, and it doesn't hurt anything. So we can keep that process going. It is so much more convenient for everybody involved. The one little downside has been if you have people like a business divorce who have been friends for 20 years and somehow it's fallen apart, most of the time they want that friendship back. And you lose the ability for them to walk into a room themselves sometimes and figure things out and go, okay, what happened? What can we do? I don't want to fight with you forever over this. And you lose that side, that personal touch a little bit, but it's more than offset by the convenience, the money savings, the ability of people to, run to pick their kids up. And they don't have to pay their attorneys to go drive an hour to mediation.
Now, do you find all the parties, including the adjusters and the attorneys and the individuals, do you find them more engaged, less engaged, or the same?
It's a very good question. I don't know. I would say as I think it through, about the same. They're there. They're not stuck in a room somewhere. So they actually, if I'm talking to the other side for 10, 20 minutes, they can be productive with that time. They could bring a laptop before and do it, but it wasn't quite the same. And it allows the clients to do the same thing so they can go check something and be productive. So that when I'm back in there, they're actually focused because they're not distracted by 10 other things piling up on their desk. the big key for that is this. And if I had my druthers, I would allow mediation to go forward permanently over video with 2 requirements. Number 1, your camera needs to be on. None of this hiding behind no cameras. Use a virtual background. I don't need to see what's behind you. It doesn't matter. But number 1, your camera's on, and 2, you cannot be in a moving vehicle, because then you're not paying attention. Driving or not, you're just not paying attention when you're sitting in your car. So those would be the 2 things that I would strongly recommend to people. And to the point of, I don't have rules I can't enforce. When I see people without their cameras on, I always ask them to turn their cameras on. You know, I'll tell them, look, it lets the other side know you're taking this as seriously as they are. But I don't have a rule, because I can't force that one. If they say no, okay.
Right.
It makes it less likely to settle your case, but I can't make you do anything.
Right. I also feel being in a designated spot is good too, with, like, you know, not distractions, like, you know, not sitting on a bench at Disney World, or not, you know, walking through.
Same idea, right?
Yeah, as the car.
I haven't seen the bench at Disney World yet, but yes, that would qualify.
I was actually on a federal court hearing sitting on a bench in Disney World, because I had no choice, and it was only phone. But I mean, it allows us to do all of these things. And I just find that sometimes we're not focused on it enough, and it hurts the client, it hurts the case, it hurts whatever. And the only thing it's helping is my pocket, because I'm working 3 cases at the exact same time, and I'm billing everybody, you know, $400 an hour.
Yeah, and you're right. It's a lack of focus when they're doing other stuff. We had a guy once. He worked at, make sure I say this very generically. He worked at a car dealership, and at first, he was out like and around. You could see him, like, can you please just move to like an office that no one's using? And he did. And it made such a huge difference, because then he was focused. And look, if we took a break for 20 minutes, because I was talking to the other side, if he needed to get up for a minute and deal with it, no problems. But then he came back in, and we had nothing else distracting him, nobody else around who could hear things they weren't allowed to hear. And he was focused in, and it was a benefit to him, because he really had some good thoughts and ideas that helped out, and he was able to express those because he was listening.
So I had a mediation that we started at 9 a.m. and we finished at 10 p.m.
Yeah.
But it wasn't so bad, because, you know, we were drafting up the settlement agreement for the last 2 hours of it, and I was able to go out and not go out, but I was able to step away from the computer, sit, have dinner, look at the agreement, get it all done. And everybody, you know, we worked to get it done. What are your thoughts on, at the end of a mediation, if you have a settlement in place, to make everybody draft it up, or, okay, we'll get to it tomorrow?
No. So what we do is, I have a mediated settlement agreement, which is just like a short version of the settlement. It has kind of the essential terms. It does not have every I dotted and T crossed, but it has the basics that you would be able to enforce with that. And I send that out from Adobe Sign or DocuSign, that people will electronically sign, so that everyone's bound and nobody wakes up the next day with kind of buyer's remorse and wants to get out of it. And if there's lots of good mediators out there. I think one of the litmus tests I would say is this: if you're talking to a potential mediator, or your attorney is, and they don't require people to sign things when it's settled at the end, that would not be my first choice, because every decent mediator I know says, no, don't ever let them leave without a signed agreement. Because
and you said it. It's because of that buyer's remorse. And I say it to my clients all the time when we finish mediation, and I'm one of the attorneys in the room. I'll say, look, I guarantee tomorrow morning you're going to wake up and you're going to say, shoot, I could have gotten an extra couple dollars, or I'll bet you I could have done this, or I could have gotten more time. You do that with everything in life. You have it, it's done. If you walk out of mediation with your fist bumping in the air saying it's awesome, you probably didn't understand something. If you walked out of mediation saying it's done, it's over, I can get on with my life, I could have done better, I could have done worse, then you're spot on. So we're getting close to the wrap up, because Mark does have a mediation that he's getting ready to prep for. So I'm going to just toss out 1 or 2 quick questions, because I like to end on a lighter note.
Can I just throw one thing in, if you don't mind?
Sure.
I didn't say this earlier, and shame on me. To your last point about feeling at the end of mediation, the reason I became a mediator is after I went through a divorce. And I was in the client chair having somebody like you telling me things I didn't want to hear, that I was really irritated about. I didn't like it. I didn't think it was fair. The whole kit and caboodle. And we had to go through 3 mediations to settle our divorce, even though we really didn't hate each other. We just had a couple things we didn't agree on. And the first 2 mediations didn't get very far because we had the wrong person. Still a good mediator. She's still out there, just not the right person for us. So finally on the 3rd one, we brought somebody else in, and she was able to help us break through the log jams we had. And a couple hours later, we had everything signed, sealed, delivered, and done. And yeah, the next day I was like, God, I gave in. I could have done better. And then 2 weeks later, I was ecstatic that I wasn't having a problem any longer. It was so much easier. It allowed us to move forward because we still had kids we had to like work together with. And it was the same for her. And we talked about afterwards how like, yeah, at first we were kind of irritated. And then 2 weeks later, we were so happy that it was done. And from that, what I like to tell everybody is peace has a value. And getting this done and moving forward carries more weight than whatever small amount you gave in more than you think you should have right away. Because there's no profit in continuing to litigate a case like that. So
how much is Aunt Esther's, vase? How much does it really mean to you? That type of thing. And I joke about it, but I mean that's truly the reality when you're fighting over some last minute things or who gets this. Does it matter? How important is it? You got the big win. You can stop paying attorneys. You can get on with your life. You whatever it is that is the reason behind it. Longest mediation you've ever had?
That's a good question. Probably like 9-10 hours. Oh, wait, I've had a few that have lasted multiple days, but for certain business disputes, when you meet the first day, you go through a lot of stuff and you kind of figure out like, okay, we're missing some of this information. The parties will go out and get it. You'll come back for day 2 and you'll work through some more stuff. So that's not unusual. But the longest in a single, like start to finish done is, man, I'd have to check, but like 9-10 hours maybe.
Yeah.
You're exhausted by the end of it.
Oh yeah. We did one for 13 hours and admittedly, there was a lot of downtime because we were doing it, but the mediator's bill at the end was 13 hours. So it was good. Most with no confidentiality, nothing given, no names, no parties, most interesting dispute that you've ever mediated, and you could be generic,
I mean, interesting. I love the business cases because there's just so many more places to be creative, and you learn about different industries that all have their like quirks and things that work really well within them that you've just never considered, whether it's the food industry or it's property or anything. I mean, it's just fascinating hearing about how they need certain things a certain way because otherwise it won't work for them. And then you got to kind of figure out why that is and then work on the other side, saying, okay, well, here's what they're saying on this. You're in the industry. Does that make sense? And it's outside the lawyer's hands at that point because they're looking at their clients. And sometimes the clients are like, yeah, you know what? He's right on that. It's not going to work if he can't do that. And sometimes they'll fight. All right, well, like, how do I explain it? Like, what is it about it?
I had a client on we had a non-disparagement clause built in that for every time they disparaged the other person, it was $5,000. And when mediation finished, I kid you not, my client wrote a check to the other side for $10,000. And he said, I plan on disparaging you. Here's the 10 grand. And we walked out. I mean, to me, that just like blew my mind.
They're mad. Hopefully they calm down and, don't.
Yeah. I mean, it was all good. And money wasn't an object. They were fighting over, other things. The money wasn't the point.
I would say the other hardest things in this, the probate or the family disputes are probably the most heartbreaking, even more than divorces, because you're not fighting over whatever the issue is. You're fighting over 20, 30, 40 years of family dysfunction and who was mom's favorite. And it's just heartbreaking because you're not going to settle all their problems. They're just so deeply rooted and you're trying to help guide them through so they don't just keep throwing good money after bad. But it's really tough. And candidly, it makes you thankful that no matter how goofy your family is, no matter how irritated you are at people, that like, okay, I still love them. This could be a lot worse.
So that's about all the time we got. I promised Mark that he'd be able to get to his mediation.
Thank you very much. I appreciate it. I got to go put my tie on for it and I will Wish you well, Jason. Good seeing you.
And again, Mark Greenberg, Breakthrough Mediation, www.btmediation.com, 561-712-4717. Attorneys, give him a call. He loves to mediate. This is what he does full time. Mark Greenberg. Pro sayers, get an attorney and have your attorney call Mark.
Please, yeah.
Thank you so much, Mark, for your time. Good luck at mediation today. Don't forget to make your tie nice and tight. Cece, for running the behind the scenes, thank you so much. And if anybody ever wants coffee, free sample of coffee, you can email me, jason@jswlawyer.com. And all you need to do is give me a mailing address, and you need to write ground or whole, and I'm sending it out. I sent Mark a package. Hopefully he got it. He'll start drinking it soon.
Thanks, Jason. Take care, everybody.
Thank you. Have a great day.
You too.